41%. That's how many people are hiding money from their partner right now. Not suspected, not accused, self-reported. And most of their partners don't know. Until it's too late. By the time people realize what was done to them inside a family court case, the case is already closed. The person is already gone. And the playbook they ran is already finished. That survey didn't come from a courtroom, not from a divorce filing, not from a forensic case file. It came from living rooms, from people who are still together, who haven't filed anything, who answered anonymously, which means by the time a family court case opens, the concealment is not beginning. It is already finished. Most people who get deceived inside a family legal case never find out exactly how it happened, not because the deception was perfect, because by the time the evidence surfaces, the case is already closed. What you are about to hear is not a theory, not speculation. The documentation is clear. Court files, forensic accounting reports, peer-reviewed academic studies, and federal criminal cases. Someone ran a playbook on you. And by the end of this video, you are going to know exactly which one. Here is what most people believe about deception inside a family court case. They believe it is improvised, reactive. They believe the other party got cornered, got caught, and started lying in the moment to protect themselves, scrambling, making things up as they went. That feels right, because from inside it was chaotic. Sit with that for a moment, because that assumption is exactly what makes the playbook work. Here is what the record actually shows. The people who deal with the most complex divorce cases already know these patterns. Forensic accountants do not guess. They follow checklists built from cases just like this. And a 10-year study analyzing over 2,000 court opinions found something even more specific: how perception is shaped before you ever speak in court. This is not random. It repeats. What felt like chaos was architecture. What felt personal was procedural. What felt like someone responding to you was someone executing a plan that existed before you knew a case was coming. The forensic accountants who trace hidden assets do not start from scratch every time they open a case file. They work from a checklist, because the methods repeat, because the people who run these playbooks, whether they know the term or not, converge on the same tactics independently, not because they coordinated, because the system has the same pressure points every time, and pressure finds the same cracks. A matrimonial attorney who has handled 300 high-conflict divorces will tell you something that sounds almost clinical when you first hear it. They can usually identify which playbook is being run by the second court date, not guess. Identify, because they have seen it before, multiple times. With different names on the folders, there are 3 of them, and by the end of this video, you are going to recognize at least one. The first playbook is the most documented, the most forensically traceable. The one courts see in some form in the overwhelming majority of contested divorce cases. It is called asset concealment, and it does not begin when the divorce is filed. That is the first thing to understand. It begins when the decision to file is made privately by one party, weeks before, sometimes months, while the other party still believes the marriage is intact or struggling or survivable, while the other party is operating on the assumption that the financial picture they can see is the complete financial picture. It is not. The American Academy of Matrimonial Lawyers has documented the specific methods used to move, conceal, and misrepresent assets before and during divorce proceedings. A business owned by one spouse gets reported at a fraction of its actual worth, not estimated low, structured low, deferred contracts, underreported revenue, inflated expenses on paper. The business exists. The value has been made to disappear. Here is what that looks like from inside a marriage. A spouse who runs a business starts mentioning how slow things are, how the contracts fell through, how this year was rough. The other party has no independent way to verify any of it. They have no access to the books. They have no reason not to believe what they are being told. That conversation, that series of conversations, is happening while the concealment is being built. Income gets deferred. A bonus is coming. A commission is about to close. The timing of that income gets pushed on paper until after the settlement is signed. Then it arrives. Cash transactions leave no paper trail that a subpoena can retrieve. Debt gets created on paper. Loans repaid to family members who were never actual creditors, reducing the reportable asset base. The money moves out. Then it moves back after the case closes. And then there is the method the Sullivan Law Forensic Practice Guide documents separately because it is the hardest to trace. A parent, a sibling, a close friend. Assets transferred out of the marital estate on paper, held quietly, returned after settlement. Nothing illegal on the surface of any single transaction. The pattern only becomes visible when someone maps all of them together. That mapping, that is what a forensic accountant does. And here is what the record shows about when it gets done and when it does not. Forensic accountants who specialize in divorce cases do not rely on what the filing party reports. They go to source documents, financial statements, tax returns across multiple years, bank records, IRS transcripts, credit reports. They run lifestyle analysis, comparing what someone reports earning against what their actual spending pattern shows. They trace foreign bank account reports. They subpoena records that the concealing party assumed would never be requested. The record on this is consistent. These tools work when they are employed. Forensic accountants are standard in high-asset divorce cases. In average income cases, the party without resources to hire one often never knows what they could not see. The concealment does not need to be perfect, it just needs to be invisible long enough. The 2018 National Endowment for Financial Education survey conducted by Harris Poll found that 41% of Americans who combine finances with a partner admit to financial deception, not from a courthouse, from living rooms, from people who had not filed anything, who were still in intact relationships, answering anonymously. The documented deception in family court cases does not begin with the filing. It begins long before the attorney is ever called. And in one California case, it began 11 days before a husband found out his wife existed in an entirely different financial universe. In early January 1997, a woman named Denise Rossi filed a petition for dissolution of marriage in Los Angeles Superior Court. Her husband Thomas did not know why she had suddenly decided the marriage was over. He also did not know that 11 days before she filed, she had won $1.3 million in a California lottery pool. She used her mother's address to receive the lottery checks, so Thomas would never see them arrive. She disclosed nothing, not in the required financial disclosures, not in any filing. She consulted with California lottery officials about how to keep her husband from ever finding out. The court found out. The appellate record documented on Justia shows what happened next. The court did not split the $1.3 million equally. The court awarded Thomas Rossi 100% of his wife's lottery winnings. Every dollar. Not because he was entitled to half, because she hid it. That is one case. One documented outcome, one appellate decision you can read today. The full Rossi case file is coming. That is Playbook 1. Recognizable, documented, named. The second playbook is harder to see when you are inside it, not because it is more sophisticated than Playbook 1, because it does not look like deception from the outside, it looks like someone telling their side of the story. Selective truth, strategic framing, the construction will bust out before you ever walk into a courtroom of a version of reality that arrives before you do. Here is what the record shows about how it works. The person who files first controls the initial framing. They control the timeline of how the case is introduced to the court. A 2026 Clio Legal Trends report found that 42% of petitioners had legal representation at the time of filing, versus 23% of respondents. The person who decides when to file is nearly twice as likely to have an attorney already in place when the other party finds out a case exists. That is not a coincidence in high conflict cases, that is a structural head start. But the filing is just the opening move. What the George Washington University study documents, 10 years, over 2,000 custody opinions funded by the National Institute of Justice, is the shaping of how a judge, a guardian ad litem, and a court-appointed evaluator perceive one parent, before that parent has had a chance to respond. The study found a documented pattern precise enough to state plainly. Courts hold certain claims with skepticism. That skepticism increases when a cross-claim is introduced. When one parent alleges that the other is engaging in parental alienation, That cross-claim nearly doubles the rate at which the court rejects the original claim, regardless of the evidence behind it. The researchers named what they found. 2 words: alienation trumps. Even in cases where courts credited findings against one parent, the other party still prevailed on custody in a significant number of those cases, not because the evidence was stronger, because the framing arrived first. The Harmon and Lorando's study, published in 2021, cited in peer-reviewed family law literature through 2024, found the mechanism underneath it. Unsubstantiated allegations, repeated, accumulated, function as what the researchers called silver bullets inside family court proceedings. Not because courts are corrupt, because volume and repetition create a pattern that looks like documentation from a distance. If you are in a case right now, so this may be the part of this video that feels like someone finally named what you have been watching happen. Not because this is about you specifically, because the record shows this pattern repeating across thousands of cases. Different names, different courtrooms, different states, same architecture. And it requires one more thing, something that lives inside Playbook 2 and connects directly to Playbook 3. Motions, filings, hearings, requests, objections. Each one requires a response. Each response requires an attorney. Each attorney requires a retainer. Each retainer reduces what the other party has left to fight the case. The American Bar Association's Family Law Division has documented this pattern directly. The most common tactic in high-conflict family cases: repeated motions filed, not all of which have legal merit, with the goal of running up the opposing party's legal costs until they can no longer sustain representation. The goal is not to win each motion. The goal is to make the next one unaffordable to answer. The narrative weapon and the financial exhaustion tactic are not separate plays. They run simultaneously. The narrative keeps the other party on defense. The cost of staying on defense drains the resources needed to tell their own story. That is Playbook 2, named, documented, running right now in family courts across this country. The third playbook is the one most people never see coming, not because it is the most hidden, because it requires accepting something uncomfortable before it becomes visible. The system itself has gaps, and some people, the ones running Playbook 3, know exactly where those gaps are. Start with the self-representation gap. The 2026 Clio Legal Trends report documents that 72% of family law cases involve at least one self-represented litigant at the time of filing. A California Law Review analysis goes further. By the time of judgment in California family cases, that number reaches 80%. 80% of cases reaching final judgment have someone without an attorney navigating a system built by attorneys. The American Bar Association surveyed judges about this directly. 62% of judges reported concern about whether self-represented litigants can achieve outcomes on par with represented parties. 62%. That is not a critic from outside the system. That is the opinion of the judges running the courtrooms. Now add jurisdiction. Family law is state law. In most states, county-level administration. Different counties in the same state can carry meaningfully different judicial cultures, procedural norms, and outcomes on contested issues. Bala's 2024 research on litigation abuse, published in Family Court Review, identifies seeking relief in different jurisdictions as a documented pattern of abusive litigation strategy. The person who knows the terrain of the local court, who files where, who has professional relationships inside that system, which procedural moves are available, in which venue, holds an advantage the other party does not know is being used. Each motion requires a response. Each hearing requires preparation. Each subpoena requires review. Each document demand requires compliance, which requires time, which requires attorney hours, which requires money. A 2019 peer-reviewed study in Frontiers in Psychology documented what the researchers called institutional violence against litigants subjected to repeated, compelled legal engagement. The ABA puts it plainly: parties subjected to this tactic are compelled to make material concessions not because they lost the legal argument, giving up support claims, giving up custody positions, because continuation became unaffordable. Hold all three layers together: the self-representation gap, the jurisdictional terrain advantage, the procedural exhaustion tactic. None of these require a corrupt judge. They work inside a fully functioning, lawful system, exploited by the party who understands it better. But the record also shows what happens when the exploitation goes further, when someone does not just know the system, but pays to bend it. In 2014, a Philadelphia municipal court judge named Joseph C. Waters Jr. pleaded guilty in federal court to mail fraud and honest services wire fraud. The federal record, documented by the FBI Philadelphia Field Office and the United States Attorney's Office for the Eastern District of Pennsylvania, is specific about what happened. Within minutes of receiving a $1,000 cash campaign donation, Judge Waters told the donor on tape, while federal investigators were already listening, exactly what she had purchased. You run into a problem with any of your people, you get a hold of me. Anything you need, anything I can do to help you or anybody that you're interested in, all you do is pick up the phone and call me. He was sentenced to 24 months in federal prison. $1,000, one phone call, one ruling. That is a named judge, a recorded conversation, a federal conviction, a sentence on the record. The full Judge Waters case file is coming, what the investigation found behind that single phone call, and what it reveals about how access to the system can be purchased is a case study that deserves its own episode. That is Playbook 3. The system has gaps. Some people know where they are, and some of those people are not standing outside it looking for a way in. Some of them are already inside it. I am telling you what the forensic record shows the early signals looked like in case after case before the pattern became undeniable. Playbook 1 shows early signals in the financial picture, not in the filing, before it. Tax returns that do not match the lifestyle. A business the filing party controls that the other party has never had independent access to verify. Sudden cash transactions for major expenses. Talk of a bonus or contract being delayed. A third party, a parent, a sibling, a close friend, suddenly receiving payments. None of these alone proves concealment. Together, documented, time-stamped, organized, they are exactly what forensic accountants look for. They map spending against reported income. The gap is where the evidence lives. Playbook 2 shows early signals in the information environment around the case. One party is speaking to evaluators, attorneys, and court-appointed professionals before the other party knows those conversations are happening. Allegations arrive in court filings before they were ever raised directly. The pattern of what is filed and when tells a story about sequence. Who filed what? Who responded? Who introduced which framing first? Framing that arrives first creates a context that subsequent framing has to overcome, not just equal. Playbook 3 shows early signals in the cost and pace of the case. Motions filed in rapid succession, requests for documents already provided, hearings scheduled, canceled, rescheduled, attorney fees climbing before any substantive issue has been resolved. A pace driven not by the complexity of the case, but by the volume of filings generating responses. All three playbooks share one thing that makes them difficult to name in real time. They each look from inside like the case just being a case, the other party just being difficult, the system just being slow and expensive and unpredictable. That interpretation is not wrong. It is just incomplete. Underneath it, architecture, sequence. A plan that was already running before the other party knew a plan existed. If you are currently in a family court case, please work with a licensed family law attorney in your state. What this video gives you is documented awareness. What you do with that awareness and who helps you act on it needs to be someone licensed to practice law where you live. Remember what I told you at the start of this video. Most people who get deceived inside a family legal case never find out exactly how it happened, not because the deception was perfect, because by the time the evidence surfaces, the case is already closed. That is still true. But here is what it means now, after everything you just heard. The evidence does not surface on its own. It surfaces because someone knew what to look for, what to document, what questions to ask before the answers became unavailable. The documented record, the 2,000 court opinions, the forensic accounting checklists, the federal criminal cases, the peer-reviewed research, that record exists because people looked, because people stayed in the case long enough and built the documentation carefully enough that what was hidden could be seen. You are watching this video, which means for you, it is not too late. If you have a case, a document, a pattern, a situation you cannot name, The submission link is in the description. Every submission is reviewed. Names protected until the record is ready. If you want to understand why these 3 playbooks work on good people who did everything right, that is what the first video on this channel is about. It is linked in the description and on your screen right now. 3 playbooks. One of them was run on you, or someone you love, or someone watching this right now who has not yet been able to say that out loud. Now you have a name for it. And if you didn't recognize it before this video, that's exactly why it works.